My paper is in two parts. Second part is very, very short, but I thought I'd start with it and just say very briefly. I think it's something we ought to attend to. It's actually related to points that Douglas Baird and Richard Epstein have made. Contract law seems to have something of a self-correcting mechanism. Most of the rules of contract law are default rules. They can be contracted around. And it should be possible, I don't know, maybe there's work on this, I don't know, but it should be possible to evaluate the rules by looking at the amount of contracting around. And that, I think, would be a very powerful method of evaluation. And if we don't do that, if we just rely on theoretical conjectures about how we might have a better system by changing this or that doctrine, I think that's a rather thin basis. And there's also the importance of uniformity. It's an awkwardness in the United States that we have 50 different states, bodies of contract law, plus federal common law of contract, very important in areas like ERISA and admiralty. And if you start changing, if you want to change contract law, the change has somehow to percolate through the 50 states. There's a protracted transition period, which there's going to be a lot of uncertainty. And there's also the factor of international convergence. Professor Grundmann gave a very striking example in answer to a question by Douglas Baird about how apparently European law reaches the Hadley and Baxendale result through the concept of a pre-contractual duty to mitigate damages. A very exotic sounding doctrine to American ears. But to the extent that very different systems of law seem to come to similar, obviously not identical outcomes, that suggests some, a kind of Darwinian process of convergence on the efficient result. So the first part of my paper is kind of an extended riff on Oliver Wendell Holmes. I'm a great admirer of Holmes. I think the common law, his book, The Common Law, is neglected, actually. And he has this neat division of tort and contract. Tort, the domain of fault and blame, and contract, the domain of faultless. I wouldn't really call it strict liability. It's really his notion of it, that a contract is an option. Perform or pay. That was discussed yesterday. And with an insurance component that Professor Cohen stressed, which I thought very interesting, bringing the great financial crisis into the room at last, that a market insurance doesn't work with contracts. So the contract itself provides the insurance that people demand. So that it very much strengthens the option theory. So now I'll take issue with Professor Cohen. But by way of background, one of the points I'm going to stress about Holmes, one of the great things about Holmes, was his desire to banish all moral talk from law. I think it's a great project. Now, because of lexical poverty, we can't actually achieve it in the way people are educated. But I think it's terrible stuff, the moral talk. So it may seem, inconsistent that he thought tort liability depended on blameworthiness. But actually, Holmes's moral view was the old Greek view, which is blameworthiness depends on consequences, not on state of mind. State of mind, that's the Christian view. The Greek view is you can't come up to the level of care of the average person and injury results. That's too bad. You're to blame, even though there's nothing you could have done to avoid the injury. So even his own moral views were unconventional. I say I don't get anything out of moral talk, even when it's not in the contract domain. So Professor Cohen starts off with what he regards the unambiguous example of blameworthiness, Judas Iscariot's betrayal of Jesus Christ. That's not true. Because if he hadn't betrayed Jesus Christ, Christ would not have been crucified. If he had not been crucified, the sacrifice, God's sacrifice of his Son to redeem mankind, would have failed.
So he's a hero.
And in the recently discovered Gospel according to Judas, one of the Gnostic Gospels, Jesus Christ says to Judas Iscariot, "You've got to betray me. It's in the plan." I have the same reaction about bin Laden. Is bin Laden evil? Well, he's evil by our premises. He's good by his premises, and there's no mode of reconciling the different premises. But coming to contract law. Now, in the discussion yesterday, efficient breach was sort of offered as the example of willful breach. But wait, efficient breach? Don't we want efficient breaches? Efficient breaches are Pareto's superior. So why do we call them willful? Why don't we, if we want to criticize people for non-performance, why not criticize as the jerk who fails to perform because he didn't buy the right supplies and hire the right people. He's incompetent. He caused a lot of damage. There's actually a reduction in the social product. But no, he's faultless. So maybe under some views he should be excused. I don't get that. Or on the other side of the moral compass. So remember Oregon, Laidlaw versus Oregon, the New Orleans tobacco case. So here's Oregon has learned about the Treaty of Ghent, ending the War of 1812, opening the tobacco export market. So it goes to Laidlaw. And, of course, he doesn't tell Laidlaw and Company. He says, I'd like to buy some tobacco, a large quantity of tobacco. Well, very quiet. And then the next day, news comes out, the price of tobacco soars. Laidlaw and Company is furious. They forcibly repossess the tobacco so that Oregon has to sue, but he wins. So Oregon's not a nice guy, right? I think a nice guy would have said, I'm going to offer Laidlaw and Company more than the market price because I'm going to make a huge amount of money and I want to share it because I'm good. We don't say that. That has no legal standing. So, on the other hand, and I think as Professor Baird mentioned, the unilateral mistake case, something, there's a mistake in the contract, and the other person has just overlooked some typo or something, and you're not allowed to hold him to it. And of course, again, you're not a nice guy, but but Oregon wasn't a nice guy. But Oregon is not a contract. Oregon gets to take advantage of the asymmetry of information and the unilateral mistake situation. You're not. So I don't get anything out of talking about fault. I'd like to see willful banished from the legal lexicon. I thought it was clear yesterday. It's a word. It does no use. It has no use at all. And I don't like the idea of talking about contract law as strict liability with pockets of fault. I don't think that's a good way to discuss. So should we say, for example, that impossibility defense is a little pocket of non-fault that, usually you're liable for breach of contract, but if you're so faultless that because it was impossible for you to perform, we're going to excuse you. No, I don't think that's helpful. I think this was mentioned in the last session. No, this is a question of, is the impossibility defense a good approximation to how the parties would probably allocate the risk of certain extreme events? It's part of the insurance aspect of contract. You don't have to bring in anything about you're faultless because a hurricane prevented your performance. So if we get rid of we can get rid of moral terms in talking about law. We can't actually purge them yet from the vocabulary of the judges and so on. So we're stuck with a concept of good faith performance. So we're not going to get rid of the term. But I think we can go behind the term and understand that what really is involved in the duty of good faith is not being permitted to take advantage of the temporary monopoly that the asymmetry of performance and payment or asymmetry of the bilateral performances introduces. And I think that enables us to understand otherwise disparate contract doctrines as all united by this very simple insight. So a best efforts clause is an example, the implied duty of best efforts, because you're giving your dealer an exclusive, you're giving him a monopoly. If he doesn't use his best efforts to promote your product, if he's promoting it, lying down on the job and so on, then there isn't anything you can do because you've agreed not to franchise another dealer. So we impose the duty of best efforts to prevent him from exploiting his monopoly. And similarly with the modification rules, Alaska Packers have a situation where the seaman in the boat in the short Alaska fishing season has a temporary monopoly. It's actually, it's a labor strike situation. And we say we're not going to enforce the modification that's elicited by the exercise of that temporary monopoly. So that's the essence of my argument. Of course, I gave other examples, but the only other point I would emphasize with regard to the option theory of contract, that it's greatly undermined if you introduce any element of fault, either on the excuse side or on the remedy side. If you say there's no strict liability, it's just a matter of whether you were negligent in failing to perform, then you're not giving the promisee the insurance he was promised, the damages if you didn't perform. And on the other side, of course, if you award punitive damages or make specific performance a routine remedy for breach of contract, then you're destroying the option on the seller's side, on the promisor's side. So I'll stop. I'm happy to have. Or you want to call?
No,
That's fine.
No, please.
No, you go.
I'm wondering if you're not being a little bit too soft and squishy in your approach. No, I'm so serious. With respect, for example, to the obligation to disclose clause in the contract. Look at Market Street. What happens in the case is the judge sends the case back for trial about whether they acted in good faith or whatever. I feel sorry for General Electric who didn't read its own contract. And you introduce the defense of good faith, and all of a sudden it makes it more problematic. You have the idea when there's exclusive dealing, there should be good faith. You say, no, why shouldn't the person just have a termination clause that gives them the right to terminate if the person isn't performing? Why inject this good faith stuff, or why read good faith into the contract when it's not actually there? And then with respect to duress, again, it's a little puzzling because I think your own, again, it's unfair to compare you as a judge with you as a scholar, but in your own oeuvre of duress cases, your basic reaction is to say, look, before you even get me talking about duress, you have to explain why you didn't go to court first. If you had access to court, then forget about it, because you either could have gotten relief from court as a preliminary matter, in which case you waived the right, or if you couldn't have gotten the right as a preliminary matter, then there's some reason the law didn't apply. So first you've got to give me that explanation. So along all the mentions you talk about, it seems as if there's some reason to regard even good faith as being somewhat suspect.
No, I agree with you about the about the duress cases. Yes, if you have a legal remedy, as the not clear that the company and in the Alaska Packers case had.
100 years ago, you were in Alaska. That was
right, and who are you going to sue exactly? Are these people
but
don't have any
in all
money
the
and
arrest
so on?
cases you've ever had, you've always found them wanting because they would go to court first, with one exception.
Well, that's fine. If it's true that duress is never a good defense because the promisee always has promisor always has a legal remedy, fine, it would disappear. But I don't think you'd want to take it out of. See, you don't want a situation in which you force people to write more elaborate contracts. I think that's very bad, and the reason for it is, apart from just the fact I once had a case in which the contract was more than 1,000 pages long, but the dispute that came into our court was over a contingency they had failed to provide. But the way I think of the judicial role in contract law, a judicial role, is that it's very, very difficult and sort of treacherous to spend a lot of time negotiating a long contract. The longer it is, the more contradictions you may run into, and so on. You can't think of all these things, and so it's very nice to be able to write a short contract in the expectation that in the extremely unlikely instance that a dispute over the contract gets into the courts, there is a body of background terms which the courts will add to your contract. So you're trading off, on the one hand, having to write extremely detailed contracts in every case, even though it would be very, very rare that a dispute over that contract will get into litigation, against a situation which the courts will plug in some of these terms, these default terms, and in the rare case that comes to court. So I don't think there's anything wrong with having a whole bunch of these default rules, and I don't suppose it's really that bad to call it a good faith duty of performance, although I prefer other terminology. But the principle of having default rules, I think, is sound. Yeah.
I would like to read for you a sentence, actually taken from your opinion about 15 years ago, and tell me whether you think that it's consistent with the argument. There is, well, maybe yes. It's not. So you say it's from the Midwest. It's AMPL. Never mind. Actually, it's from 1990. You say the parties to a contract are embarked on a cooperative venture, and the minimum of cooperativeness in the event of unforeseen problems arise at the performance stage is required, even if not an explicit duty of the contract. Right? So there is a kind of an implicit duty to cooperate if there are some unforeseen contingencies in performance. That's the way I understand it. Now, how exactly you define what is required here? Right? Should they behave reasonably? And if yes, it becomes a kind of a fault argument.
Well, I don't remember the case, so I don't know the context of that sentence. There's no general duty of cooperation, being a good fellow or anything like that. But obviously there are specific. I mean, the longer the contract, the likelier it is that there are going to be changed conditions that may, make the contract fail unless you imply into it some condition that the other party had to do something. But I think one can talk about cooperation without getting into the moral language. It certainly would be wrong to say that it's a breach of contract to be uncooperative. You can be very stubborn in negotiation. You can, when the pathetic promisor comes to you and says, I need more time and this and that, you can take a very hard line, say, go, you can always petition for bankruptcy. But in specific situations, many of which involve these temporary monopolies that contracts create, then I think you can say, yeah, there is a duty to to do something or to not do something, and that is a sensible implied term. Yeah, Eric?
I think you're using blame and fault in two ways, a methodological way and a substantive way. So it's very easy to provide an economic account of fault. As you know, since you've done this in, let's say, tort, right? So you think fault and tort is just a handful. It's not a moralistic idea. Well, I think it's moralistic. It's just sort of welfareist or utilitarian or something. But that's easy enough, and one could do the same thing in contract law. One could come up with, basically, I think this is what Ariel is asking. You could say that although there's an absolute duty, it will imply a condition, which just means we're making up a condition, that you have to act reasonably, which really means that if you can incur flow costs in order to confer benefits on the other party which are higher, you have to do it. That's a purely economic account of fault, just like in the hand formula in tort law, and that can be applied in contract law. And then you need to give economic arguments for why that might be improper. But most of the paper seems to be more methodological, which is that you don't like this, where you're criticizing fault, you're not criticizing that type of argument, the kind of hand. You're criticizing what seems to be some kind of attempt by people to apply, I don't know, common sense morality or sort of morality that we teach our children to observe in the sandbox, or that sort of thing. And you think, applying that to contract law is a bad idea. But that may be right, but that's completely different from the argument about whether strict liability or negligence should be the rule in contract law. That argument is just like the argument in tort law, whether you should have strict liability or negligence, and that's a question of looking at the various, costs, decision costs and error costs on one side, and the other types of costs on the other side.
No, I agree with that. Yes, because obviously we can talk about negligence without bringing in any moral talk, and in that way the hand formula is a step beyond Holmes, because he did keep emphasizing the role of blameworthiness in tort. But yes, you can do that, and then my argument would be that the reason that negligence doesn't work is that if Holmes is right, and I agree with Holmes that a contract is an option and with an insurance function, then you don't want to excuse non-performance on the basis that the cost of performing would have exceeded the benefits.
You have made negligence arguments for contract law in your own work. So in the 1977 paper that Richard mentioned the other day, where you provide an economic explanation for the impracticability and impossibility doctrines, you have a more complicated test. But one of your arguments is that the court should excuse somebody if basically the other party is the cheaper cost avoider, and then you also have a separate test about which party is the cheaper insurer. But putting aside the cheaper insurer example, the first test is just the hand formula as applied to the
right. No, that's fine. And another example would be who is liable, the seller or the buyer, if a fire destroys the goods, in delivery or before delivery, after delivery. Yeah, no, that's fine.
So this happens in the people like Scott and Getz, when they analyze good faith, which you don't like, they just want to say good faith. There's another example where we make this type of hand type analysis. When we're applying conditions, this is yet another example where we make this hand type of analysis. And as we do this over and over again, the strict liability idea of contract begins to disintegrate, maybe not completely, but we have these additional exceptions, all of which are based on this kind of cost-benefit approach.
I don't think it discriminates. I don't think it. I don't think it disintegrates because you still have the very basic difference: no punitive damages in contracts, no specific performance unless the no injunctive relief unless there are special circumstances. I think that's very important. But I took the title of the conference more literally. I thought fault. Yeah, fault. Professor Schifrin, right? Fault. That's the notion that there isn't enough of a moral, that the moral impulse is not sufficiently influential in contract. But certainly one can debate the proper structure of defenses and so on in strictly economic terms. Hey, Rich.
Yeah, I've always been curious about your reading as Holmes, because my view about it is in this, for example, in the common law, one of the reasons it's a great book is that it takes every conceivable position within a very short compass. And that you could find as many passages which extol the importance of justice and moral virtues. And so let me just sort of read you a couple of them and tell me if this is the kind of thing that you really do aspire to. He has one passage where he wants to talk about, causation. He has this notion that, nay, why need not the defendant have acted at all, and why is not it enough that his existence has been at the expense of a plaintiff? This is a man who's lost his head when he made that sentence. The requirement of an act is the requirement that the defendant should have made a choice. But the only possible purpose of introducing this moral element, so he talks about moral elements again, is to sort of make sure that that you have responsibility. Later on in the same passage, he talks about redistributing losses simply on the ground that they resulted from the defendant's act would be not only open to these practical cost defenses, but to the greater one of offending the sense of justice is the word that he uses there. Now, I think everything he says in this passage is completely incoherent, so I'm not trying to defend him. But I do think that in his cases that he is extremely elusive, and that you could find passages where he talks about liability at fault, or proper fault is the phrase he uses in the passage you're referring to. But I just am utterly mystified why anyone would find in all of this sort of elegant prose anything that looks like a consistent vision, given the fact that he deviates from the vision on one page that he announces on the second.
No, it's completely consistent.
Moral element is
what he's saying. No. What he's saying is there's no basis for strict liability in tort, because the fact that your act caused an injury has no moral significance in Oliver Wendell Holmes's moral universe. But if your act resulted from the fact that you're incapable of reaching the level of average avoidance of injury, then you are at fault. You are blameworthy. That's what I call his Greek theory of morals.
But he doesn't believe that either, because when he talks about the insane people, he says that they have to make adjustments for them as well, on the basis of their incapacity. So it's completely selective. He does the same thing with respect to infants. I think he's wrong on some of this stuff, but I think the key line is the stranger, Mesicon. Somebody takes me out in a car, and I'm an experienced driver. He doesn't know how to drive, and I'm going to teach him. I think I take the risk of his incompetence, given the selection factor. But if I'm a passenger on somebody else on the side of the road, and this fool runs me down, I don't think that I do. And Holmes, in his stuff on torts, he's writing in 1881. He doesn't once consider assumption of risk in industrial accidents, which was the dominant question at the time. I mean, the man was completely blind to all of this stuff. So, given the incoherence and given the selective topics, I just don't get the hero worship. I mean, I don't want to say he's a non-entity, but
well, no, but
it's a complete mishmash on every issue. The book.
You're talking about a book that's 127 years old. The fact that Holmes did not have the benefit of another 127 years of thinking about these problems shouldn't
I think it's a great
topple
book.
him from his perch.
Look, I mean, it's one thing to say that he's immensely suggestive, But it's another thing to suggest that he has a coherent view, and the tensions.
Well, who has a coherent view? There's not. There is not one person in this room who, in 127 years, will be described as having had a coherent view. Right?
I think people will be. I mean, you certainly say, you don't say about Kant that he had an incoherent view.
Oh, come on.
You said he was wrong in many cases. I think that's just wrong.
Even the Kantians are busy tearing down Kant.
And they were criticizing. Look, this is also wrong. By 5 years after he wrote this book on many things, people were attacking him for these incoherences. It's not that I'm the first one to point them out. And so you have to explain why it is that when people wrote about him all these earlier times, including his option theory, that it's only the benefit of 125 years to do it. I just don't think it's true. I mean, you got to accept
the fact that a person is criticized within 5 years doesn't mean his ideas are wrong.
No, but it does mean that you can't say that it's only the benefit of the future. The weaknesses were well exposed at the time.
Well, I don't think his option theory is a weakness.
Well,
I think it's a great theory.
That's a good weakness.
And poor old Holmes, he wasn't even a full-time professor.
I know that.
Well, did you want to make some allowances?
No.
No allowances.
Actually, when he wrote the book, he was
6 months.
He was at the Harvard Law School before he was appointed to the bench. And
He wrote the
guy
book before his Harvard.
Well, no, he gave the lectures early and wrote it up later.
But he was at Harvard about 6 months.
Yeah, and then before that, he had done Kent's commentaries. I mean, the man was, in fact, doing.
Yeah, but he's practicing law too.
Yeah, but he was a tremendous academic.
To make some allowances.
I don't make allowances. I certainly don't make them for judges who write.
I know. But his option theory of contract really does clarify the issues that are involved. That is, you can talk about the contract doctrines without reference to fault, even in a situation where a person simply doesn't perform, which seems like kind of prima facie an immoral thing. There's a lot of talk of that yesterday, but I think Holmes explained clearly for the first time how it is that you can justify this kind of casual attitude toward keeping promises. Yeah.
Can you say more about what you understand the Greek idea with respect to these matters is, and how it bears on your argument?
Yeah, well, this has been revived by philosophers like Bernard Williams and Tom Nagel under the rubric of moral luck. So you have two people driving equally recklessly. One hits someone and the other doesn't. So you'd say, well, they're equally blameworthy. They were both reckless. They knew they were reckless and so on. One is going to be punished. The other is going to be ignored unless a police officer happens to be on the scene, give him a ticket. But if he's given a ticket, maybe he'll be given a $100 ticket. The other person may be prosecuted for, reckless homicide or subject to a big tort judgment. So it looks as if we actually make distinctions, moral distinctions, on the basis of consequences rather than just state of mind. And the idea is Greek. It's pre-Socratic Greek. If you screw up, you're a bad person, even if you're not, even though your state of mind was entirely innocent. And that, as I say, is the Holmesian view of, in the passage, I think it was either Richard read it or it was right close by when he says that, if you happen to be born clumsy, and awkward and so on, as a result you injure people and a normal person wouldn't. Well, it's not your fault that you were born that way, but nevertheless, we blame you. And that's his tort theory in a nutshell. Yeah.
Just want to push you a little bit on where you place the boundary of moral judgments, because obviously there's an implicit moral judgment that we should try to achieve efficient or Pareto optimal results, and yet you're also saying that we need to take these moral judgments out of our formulation of the contract. And I'm wondering what the principle is you use to say we need to make these normative judgments in one case and not in the other.
I wouldn't make that judgment at Pareto superiority. I think that is the I think that's the most plausible social function to assign to contract law, promoting efficiency. But if you wanted to say no, what contract law should do is promote warm feelings of mutual trust, I wouldn't argue with you. Yes?
The idea of traits is really interesting. A couple of the papers yesterday suggested it a little bit. They didn't really come out and call the theory as theories based on traits. I'm talking about the two co-written papers from yesterday, where the information-based theory paper seemed to suggest that an actor acting with low integrity, which is a trait, called a trait, systematically over time when actions lead to undetectable breaches, justifies supercompensatory damages, right? Something like that. So there's a trait idea there. And then in the paper that followed it, there was a trait idea, the other co-written paper, in that if a promisor is in a position to avoid the breach by taking an action that is little to no cost, but doesn't, that's blameworthy in a particular way that we haven't previously recognized. It seems like there might be a trait idea there as well if what we're talking about is if you're in a position to take a precaution you don't, why not? Is it because you're maybe lazy or you didn't plan out the cost of performance well enough, you just lacked good judgment? And this idea of trait, when I was going to ask the same question about the Greek idea, I wondered if maybe Holmes's idea, because I just don't know, and I was also going to ask about it, is Aristotelian. You've put it as pre-Aristotelian. But the idea that defining blameworthiness not as fault, as in deontology, but also pushing it a little bit and giving more content to the cheapest cost avoider notion, kind of opens the door almost to a whole third normative conception. And I'm wondering if that's something you've thought about or are open to, if this is making sense. Is there a lesson in Holmes's reliance on the Greeks for us today that kind of might break the logjam between fault and other kinds of blameworthiness that are tied to fault?
Well, let me make sure I understand. So what you're concerned about is a situation which I understand to be what Oren was talking about just, a situation in which a person by his behavior in a series of contracts has demonstrated a trait, some character trait which makes him an unreliable contract partner, and once that trait has been proved, should that lead to a higher sanction, try to kind of expel him from the commercial sphere. I wouldn't be inclined to go that route, partly because I think ability and being a sharp elbow type person are closely related. You know, the Pritzker, Jay Pritzker, who was the deal maker of the Pritzkers, he was reputed to be utterly ruthless as a negotiator. And the Microsoft Corporation, under the great benefactor and international global charity dispenser Bill Gates, had a very well-established reputation for absolutely ruthless dealing. Well, when this becomes known, that really arms the opposing parties in the transaction to protect themselves against these people. Reputation is obviously a very important factor in one's ability to negotiate the commercial market. And the more you're engaged in the contractual process, the more established and prominent you are, the greater your commercial activity, the more your reputation becomes well understood. And then, as I say, once someone's reputation is correctly evaluated, you can, it's again self-correcting. The people who deal protect. Now, there's a whole class of contracts we haven't discussed. I just mentioned in passing. There are certainly exploitive contracts involving ignorant consumers and so on. We have a whole body of law to deal with them, statutory law. And we need it because the stakes usually are too small to justify a lawsuit. So we have class actions and statutory damages and so on. So that's fine to deal with extreme asymmetries of information. I have no objection to that. But again, I would prefer to discuss those in a non-moral vocabulary. Yes?
Can I just
Warren?
perhaps correct some misunderstanding about this part of
Mm-hmm.
our theory from yesterday? So we're not arguing that these supercompensatory damages in this case are designed to kick these bad actors out of the marketplace. On the contrary, the argument is if we have these two types, there are different types of actors, and the other contracting party doesn't know or can't distinguish between them, the only way that perhaps the low integrity actor could in fact engage in these market interaction is by committing to the high damages that would therefore tell the other party, I will not breach, even though I'm not as high integrity as some other guy. So this would be, I think, in line with your theory of just tracking what the parties would have wanted, including this low integrity person, and allowing him to participate in the marketplace.
No, I agree with that, and it's an argument for allowing penalty clauses, right? Because penalty clause is a way. It's not only a way of offering more compensation for a breach, but it's a mode of signaling, right? You may think I'm, really, I never perform my contracts, but I'll try. And it's like loan sharking, right? So if you know you're going to have your knees broken if you don't repay the loan, it increases your incentive to comply. So you can actually benefit by agreeing with the creditor that he can break my knees.
So we should enforce the promise.
Pardon?
So we should enforce the promise.
Should we enforce the knee-breaking promise? No.
What do you think? You're getting soft again, huh?
No, we shouldn't. We shouldn't enforce that. But the reason we shouldn't enforce it is, I don't like the moral talk, but every society has moral principles, and when they're very strong, they're going to override utilitarian calculations. Like, I don't know what you think about this, Richard, but should we permit gladiatorial combat? Right? If two people agree they're going to fight to the death, they agree. They're competent adults. There's a big purse for the winner. Should we enforce that? No, we shouldn't enforce it, obviously, because it's deeply offensive to people. I don't think we have to get into reasons for that. Pardon?
See, that doesn't solve the problem, because you said we're not going to enforce it through our public system. But are we going to use the public force against it?
Yes, we are, obviously.
Well, but then,
right?
of course,
Obviously.
we have to have a strong moral
No,
view.
you don't have to have a view. No, you don't have to have a
So
view.
the new theory is whatever Lola wants, Lola gets.
No. There's no point in arguing against
This is homesick.
deeply ingrained moral feelings that people have, right? It's just, there's no gain from that, right?
We
No
tried
gain
against
from that.
slavery. It might work.
Pardon?
Yeah. The abolitionists should have just remained quiet.
What the abolitionists did not present arguments, right? And the reason that slavery was abolished in the United States, of course, was because of a war. And it wasn't a war to free slaves; it was a war to maintain the Union. So I don't regard references to slavery as any kind of killer. We have forms of slavery; we just don't call it that, right?
Good jobs.
We have 2 million people in prison. What are they? They're slaves. So slavery is just, the term for the types of coercive labor that we happen at some particular historical interval to disapprove of. I'm just suggesting that there's no particular profit in arguing over these moral issues. If we had the kind of society in which people had very strong moral views about keeping promises, then, well, you'd have to yield to that. But since we don't, it seems that we can improve our understanding of contract doctrines by discussing it without any reference to these moral terms. Yes?
Question about how wide this view is. So one take on the separation of the language of morals from the language of law is we actually want two languages. So I want to be able to think, oh, this guy who doesn't keep his contractual promises is a bad guy. I want to be able to blame him morally, but I don't want the state to be in the business of doing more than making him compensate by paying expectation damages, because I think there's a special role for the state, and that is guaranteeing efficiency. Meanwhile, in our moral discourse, it might be good to separate out the good types from the bad types. We can do all kinds of things with that, and we have a rich cultural world by separating out good types of people from bad types of people in the same way as we separate out good types of music from bad types of music. So that would be one argument, and then we actually do want to be able to use moral language, but not when we decide what the law will be doing. But then it seems like you're also making that you might not be making that argument, but you might be making a much stronger argument, which just says, on the moral issues, since there's no baseline, or there's no measure of evaluation on which we could agree, we just shouldn't talk about it. We should get rid of that language more generally, not only when we're talking about what the state should do as opposed to something else, but it's just not worth talking about. It's not worth talking about moral convictions or about morals, because one person will have his morals, another person will have his morals. It's like talking about whether we like vanilla or chocolate, not worth the discussion. And I was wondering which of those.
Well, for purposes of the paper, it's the first view, and I think the best example of that was Islade Law versus Oregon. Yeah, Oregon wasn't a very nice guy. He was a Sharpie, took advantage of the other party's ignorance. So we might criticize him, but we should not impose liability. As we should let him enforce his contract. As I mentioned, it's an example of private vices creating public virtue. I'm somewhat sympathetic to this the more ambitious view you attribute or you suggested, but it isn't really related to the paper. I think moral reasoning really empty stuff, and the reason is it's not that it's like your choice of ice cream. It's that people argue from different premises, and an argument from different premises can't be resolved. That's the problem with bin Laden. It's the problem with abortion. If you believe, the fetus is ensouled at conception, I could say I think that's nonsense, but that would be the end of our conversation. And I think that's true of. We have a very large area of moral consensus in the society, but the issues that people want to discuss are the ones where the reason there isn't a moral consensus, or the main reason is that people argue from incompatible premises, and therefore there's no resolution. So it's just kind of propaganda, advocacy, emotion, which has a role, obviously, trying to excite people, show pictures of the fetus in order to bring people to your side, which is fine, like the pictures in Peter Singer's book, Animal Liberation. But that's not reasoning, so I don't. But I particularly don't want to see this moral reasoning brought into contract discussions, because I don't think it does anything, and I don't think, especially going back to the second part of my paper, would I think be particularly inappropriate to suggest recasting contract law in moral terms, given what tremendous transitional costs and misunderstandings and so on would be engendered by such a project. Yes?
I want to go back to the option theory, Holmesian option theory that you like. And I'm kind of wondering, how do you choose what to like among the three following candidates? One is promise has no option whatsoever. The other, the Holmesian notion that promise is coupled or bundled with an option to pay damages. And the third, let's invent one. In fact, there's some study of it. There is an option to breach and pay damages, but then there is a reverse option to compel performance. So there's kind of dual option. So, and you can invent more option kind of schemes once you want to get sophisticated. And how do we know that Holmes got it right? If you can use several methodologies. You can kind of ask people, what do you think an option is? And if you ask, I think the popular response among transactors, lay people, and scholars at the ALI meetings is it's the first. There is no option. And if you ask some economists, they'll say, no, there is, we think that it might be optimal. So then the other methodology might be, let's find which one maximizes well-being in some ex-ante sense. It's not clear that Holmesian option is good. Many people think that the European scheme of no option creates more well-being by propelling more renegotiation. So how do we how do you decide to like Holmes in that sense?
Well, your point is kind of the obverse, not the converse of my part two. That is, because theoretical speculation about contract law, even when cast in economic terms, has a substantial amount of indeterminacy, we ought to be hesitant to base proposals for changing law on new theories in economics. I think about the most one can say about the option theory is that it's plausible. That is, it explains, for example, why the basic regime is strict liability and why we don't award punitive damages and specific performance is exceptional. You have to tie it in with a notion that there is a demand for insurance for breach of contract, but as Professor Cohen mentioned, it can't be bought in the market. And so it can be provided by having this strict liability regime where the payment option is the insurance part of it. So it's plausible. It's certainly simpler than your third example with a reverse option. And the second, one can see all sorts of problems with the second, with having specific performance, the normal remedy. It means you have to build in a lot of more excuses in order to make that workable. I was comforted by Professor Grunman's suggestion yesterday that actually, despite the formal priority of specific performance as a contract remedy in Europe, the judges often tell you, no, you'll have to settle for damages. And but no, I agree with your basic point. We don't have the theoretical tools. It's not like 2 + 2 = 4. You can't make mathematical demonstrations of economic principles. On the other hand, if your reverse option suggestion were good, wouldn't we expect to see it or some version of it in contracts? Right? people who make contracts have obviously a sense of how they can promote their welfare by new contractual instruments. I don't think you can make a contract that requires a court to order specific performance. I don't think that washes. But through arbitration, through guarantees, and so on, you can achieve. So if it turned out that there were a lot of these contracts being made, then one would want to re-examine the Holmes view. Incidentally, is there much empirical work on contracting around? Because I know, is it Washington University that collected some gigantic number of contracts? I think it was a project started by Coase. It started at Pittsburgh and then moved to Washington U. But somewhere I know there is a great body of contracts, and I wonder if anybody, is using them to study these issues. Yes, well, that would be the kind of study that would illuminate issues of this sort. Yeah. Right. Yes.
So I wonder about the divide again, which we've talked about a lot between morality and the law. It seems like from a political point of view, morality doesn't have to be consistent or coherent at all. It's just some stuff out there. But every other branch uses it a lot. I mean, if you consider anyone who's running any kind of political office and so forth, for them it's a low-cost means of reinforcing their judgments. It seems to me at low cost. It's just they don't have to have a coherent theory. They just have to have the language that has some kind of creates some kind of moral motivation in the people to act a certain way. And it doesn't seem to me like courts can't do that in the same way that we can come up with we can use economic basis to explain stuff that, for example, is in the Old Testament in order to make economic sense of that. If we're looking for a certain conclusion, it seems like a low-cost way of doing that is to bring in moral language, especially in cases of deterrence, like we do in the criminal law all the time. We talk about malice or some kinds of morally loaded language. So why would we never do that in contracts?
Well, I think there are situations. I think criminal law is a good area. There are situations in which the moral language is pretty well understood. So when we talk about criminal responsibility, and a criminal, in order to get a sentencing discount, you're supposed to accept responsibility for your crime, right? So, and there's a paradox there, because if you blame evil companions, you're not accepting responsibility, so you don't get the discount. You're supposed to take all the responsibility yourself. But then you're calling yourself an evil person who acted without any justification or extenuating circumstances. So it's a strange charade. But all it really means is that we're trying to make a distinction between injurious acts that are deterrable and injurious acts that aren't. That's really the basis of it. And our focus is really not on the criminals, many of whom are undeterrable, obviously, but on a kind of intermediate category of people who would commit crimes if there weren't punishments. So there, I think it's all pretty clearly understood what's going on. Or when we say, confession is admissible in evidence if it hasn't been coerced. If the person, again, as an exercise of free will, he decided to confess. That's kind of baloney, but it doesn't confuse people. But very often, I think judges are confused by moral language because some of the moral language is just too vague. Now, so I cringed a little when Professor Craswell twice yesterday mentioned fairness. And there was a kind of a faint implication that someone who came up with a fairness argument might upset his entire economic apple cart. That there are these trumps floating around, powerful moral concepts. Well, I don't think the word fair has any content at all. And I think when the judges start talking in that language, it's a kind of mental laziness. The problem with judging seems to me, with law in general, it's stays too much on the semantic surface. And lawyers love rhetoric, judges love rhetoric, and these moral terms play an important role in legal rhetoric. But it's a rhetorical role. I don't think it's analytical, and I think it causes confusion. And I think it would be very unfortunate to have a kind of creeping moralization of contract law, because I think we do fine in terms of our actual objectives by translating the moral terms into more concrete, pragmatic